Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, on Friday, it was pretty late Friday, but Friday, I believe it was late afternoon in New Mexico, the judge in the Alec Baldwin manslaughter trial, involuntary manslaughter trial, dismissed the charges against Alec Baldwin. This is due to Brady violations, lots of issues with the state, the prosecutor, Morrissey, as well as some others. And I'm going to play what the judge had to say when she dismissed the case.
So, dismissal with prejudice is a very extreme sanction. And case law is very clear that because it's very extreme, I have to go through every single element, and I have to make a very good record as to why I'm seeing what I'm seeing. So, in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teske gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state, quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions under Harper. Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated. State v. Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has power, inherent power. Per State v. Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted.
You know, this was the right decision. As much as I don't believe Alec wasn't culpable for some of his actions or inactions on the set of Rust, the state was completely dishonorable. They kept vital evidence from the defense, and from what I understand, the prosecutor Morrissey, she's probably facing a lot of trouble with the bar, and who knows if she'll be practicing law anymore. And the other, her co-district attorney, right before this dismissal was announced by the judge, she actually stepped down off the case. So, a lot of corruption, and I'm not an attorney, so I can't explain all that other stuff, but it was a hot mess, and as if it wasn't crazy enough, the insanity and lack of safety on the set of Rust, it's as if the law enforcement and the DA's office, they continued to bumble things, and not only did they bumble things, but then they kept these live bullets. The discovery that this witness, came forward to the police department and brought these bullets to them. So there's a lot to it. I will include the link to explain further if you guys want to check it out. I'm sure some of the other attorneys, I know the DUI guy was there at the hearing, so he has a lot of insight. I listened to some of his stuff. Highly recommend him. He's very, very knowledgeable. He's an attorney, and I did enjoy listening to his commentary on Friday. But again, this is a sad situation, but it was the right thing to do, and I applaud the judge for this. And it's really crappy that the state did this. It makes all of them, and then the crime scene, the tech, Popple, she's also at fault. So again, I think a lot of crap's gonna run downhill on this one, as far as the prosecutor's office and law enforcement. I'm sure we'll be hearing those updates in the coming weeks here, but meanwhile, this is over. I wanted to just kind of close it out here on the channel since I was going to be covering it, and I put a video out, and I had been listening to most of the testimony. I missed a very small bit, but I could already tell it was a hot mess, but once they got to the part where there was evidence kept from Alec Baldwin's defense team, whew, I couldn't believe it. I could not believe it. Alright, guys, let me know your thoughts on this one in the comments if you followed it, if you watched it. I am curious. But again, this one is done. And as we can see, Alec Baldwin, he was crying and he's relieved. And I know he and his wife shared some hugs and kisses, in the courtroom. Alright, I hope you have a great rest of the day. And most of all, stay safe.